Article 2, the Vesting Clause. Common interpretation by Shai Krishnam, B. Prakash, and Christopher H. Schroeder. Article 2, Section 1 begins, the executive power shall be vested in the President of the United States. And a minimum, this vesting clause establishes executive office to be occupied by an individual. And the founding, the creation of a separate executive was hardly obvious. The Articles of Confederation created no separate executive. Duties that we associated with the executive were handled firstly by congressional committees and then by secretaries or boards under congressional direction. Nor was it self-evident that one individual would stand at the apex of the executive. Several states had plural executives, executive committees, and the notion of a plural executive had its bankers and the Philadelphia Convention. Few could disagree that the vesting clause establishes a unitary executive in the sense that it creates a single executive president. Throughout our Constitution, the history, some politicians, judges, and scholars have argued that this minimal sense exhausts the content of the clause. Others have argued that the clause does more and actually grants the president the executive power. In recent years, advocates of the latter view has identified their position with the label unitary executive. But this label is a bit misleading, for would do well to remember that the idea that the Constitution established a unitary executive is perhaps universally shared, at least in the minimalist sense outlined above. In this disagreement, two issues predominate. First, does the term executive power identify a set of powers beyond those expressly identified in the Constitution, but which are nonetheless given to the President by virtue of the vesting clause? Vesting clause minimalists often claim there was no settled meaning to the term at the time of the founding, and that is, the executive powers of the United States refer only to those powers elsewhere assigned to the President. The unitary executive position is that the founding executive power refer to a suite of powers, such as the powers to execute the law, appoint officers, communicate with foreign governments, formulate foreign policy, wage war, and the like. The vesting clause grants this entire suite to the President, subject to express limitations in the Constitution. The President may not appoint without securing the Senate's consent, for instance, and Article 1, Section 8, Clause 11 provides that the Congress shall declare war, with the implication that the President cannot. Second, by vesting power in a singular executive does the vesting clause establish that the President may exercise those powers by himself without interference by Congress, and concomitantly does it give the President the authority to direct and to supervise any federal official involved in such matters. Advocates of the unitary executive position often assert that the President can exercise his constitutional powers without congressional interference, and that he may direct executive officers. For their part, vesting clause minimalists tend to claim that Congress, through the exercise of legislative powers, including the necessary and the proper clause, can qualify or regulate the President's exercise of powers that has not been clearly assigned to his sole discretion so long as Congress does not impede the President's ability to discharge his constitutional duties. Notice that neither the two unitary executive positions nor the two minimalist positions are necessarily linked to one another. One could conclude that the Western clause minimalists have the better case on the first question, while the unitary executive have the better view on the second, for example. Yet in practice, people often adopt one pair of relative views and the other set. These questions matter. In their purest forms, the two understandings of the Western clause, the minimalists and the unitary executive, imagine quite different allocations of power and institutional arrangements. If the unitary executive stance were to prevail, perhaps all of the independent agencies of federal government, from the Federal Communication Commission to the Federal Reserve, would be unconstitutional because of congressional restrictions placed on the president's authority to remove members of their commissions or boards. After all, these restrictions would be seen as unduly inhibiting the president's ability to supervise and control. But if minimalists have the better reading of the Western clause, would prevent Congress from granting removal protections to the entire bureaucracy, including such officials as the Secretary of State or the Attorney General, so long as it leaves the President's ability to ensure faithful execution of the laws, Congress might be able to radically refashion his relationship to departments long thought of as executive and under his supervision. Judicial doctrine on these questions is mixed. The court has from time to time endorsed the idea that the Western clause was a power independent of the rest of Article 2. In a case involving presidential dismissal of a postmaster, Mears v. United States, 1926, the court claimed that the Western clause granted authority to execute law and to remove executive officials. In decision from the late 19th century, in Re Nagel, 1890, the court upheld the authority of the president to assign a federal marshal to protect a Supreme Court justice who had been threatened by a disgruntled litigant despite the absence of any statute granting that authority. United States versus Curtis Wright Export Corporation, 1936, the court famously announced that the president was the sole organ of the nation in its external relations. In the 21st century, the court observed American Insurance Association versus Garamendi, 2003, that is a historical gloss on the executive power conferred upon the president the vast share of foreign affairs powers. Yet in a series of removal cases, the court has also proved congressional authority to insulate public officials from executive control. In the case involving the Federal Trade Commission, Humphreys Executor versus United States, 1935, the court held that Congress could limit the presidential ability to remove a commissioner. Similarly, in Morris versus Orson, 1988, the court sustained a law that said the executive could remove independent prosecutors for just cause only. The law gives the president sufficient authority to ensure faithful execution, or so the court held. And it should be noted the court sometimes avoids resolving questions about the meaning of the Western clause, choosing to rest its decisions on other grounds. Arguments about the Western clause surface whenever the government takes action that might not fit squarely within existing understanding of a whole the Constitution separates powers. Can the president unilaterally terminate a treaty? Can the president resolve international disputes through agreements negotiated by him and then submitted to Congress for implementing legislation as needed, thus operating outside the treaty clause? It is much more likely that the branches will reach provisional understanding on many of the disputed questions through the nominal processes of politics than that the Supreme Court will clearly and once for all declare one or the other view correct. In part, this is because similar results in many cases can be reached through statutory construction or reliance on other constitutional provisions without reaching difficult vesting clause issues. In part, it is because separation powers questions often rely heavily on historical practices for the resolution. Matters of debate, the first perspective, the significance of executive power by Krishna B. Prakash. Article 2's modest list of specific powers might lead one to suppose that the president was meant to have but a few authorities. He can pardon people as commander-in-chief and with the Senate's consent can appoint to office. So an express duty to ensure feasible execution. One could read the Constitution was never granting him any authority to execute law in the first instance. Moreover, he seemed to have but a slender connection to foreign affairs, with the duty to receive ambassadors of power, subject to substantial Senate check on making treaties. This familiar, powerful presidency of today may seem surprisingly unconnected to the Constitution's actual text. Yet from the Constitution's inception, the presidency has been a powerful institution. Early presidents from Washington on assumed the host of powers over law, execution, foreign policy, and executive officers. In particular, Washington and its successors controlled correspondence with foreign countries, directed American ambassadors, ousted foreign ambassadors, executed federal laws, directed prosecutors, and regularly commanded and removed executive officers. No statute authorized these actions, rather their common foundation arose from the Constitution, which grants the President the executive power of the United States. Presidents continue to exercise such powers all without statutory warrant. Grants of executive power were familiar, primarily because most extant state constitutions expressly grant such authority in contexts where it was clear that the provision granted a suit of powers. The Constitution replicated that system. As Alexander Hamilton put it, the Constitution's general doctrine is that the executive power of the nation is vested in the President, subject only to the exceptions and qualifications which are expressed in the Constitution. If that is the doctrine of the Constitution, what are we to make of the particularized grants? Hamilton again had the answer. Enumeration of particular authorities ought rather therefore to be considered as intended, by will for greater caution, to specify and regulate the principal articles implied in the definition of executive power, leaving the rest to flow from the general grant of that power, interpreted in conformity to other parts of the Constitution and to the principle of free government. This structured general grant, followed by clarification and limitation, was hardly unusual, and James Madison put, nothing is more natural nor common than for to use a general phrase and then to explain this, qualify it by a recital of particulars. Article 2 followed that natural structure. Two vital constraints hem in the vesting clause's rule that the president enjoys those powers traditionally vested with the chief executives. First, the vesting clause never grants to the president the powers granted elsewhere to Congress. Hence, our president cannot regulate foreign commerce or declare war. Stripping away these traditional executive powers helps ensure that the presidency is not too formidable. Second, the specific constitutional check restrained executive authority. Despite the grant of executive power, the president cannot appoint or make treaties without the Senate's advice and consent, nor can he pardon impeachment convictions or violations of state law. Executive power minimalists make some respectable arguments, yet none of them can overcome text, history, and long-standing practice. First, their claim disregards the 18th century meaning of executive power. Executive power was not an empty phrase. Rather, it encompassed control of law execution, foreign affairs, and executive officers. Second, rules of interpretation oblige us to heed the differences across the first three articles. Article 1, Section 1, all legislative powers herein granted shall be vested in the Congress, evidently meaning to vest no powers separated from those specifically enumerated in Article 1. In contrast, Article 3, Section 1, the judicial powers of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may establish, clearly vests the federal courts with judicial authority. The executive vesting clause has the structure of its Article 3 compartments in contrast with Article 1 clause. Third, although many sometimes see the wish to avoid redundancies, their theory generates a word problem. The rest of Article 2 makes abundantly clear that there would be only one executive style of the president. Article 2 repeatedly mentions the president and use the pronoun he. Hence, minimalists would have us read the vesting clause as if it served no purpose. From time to time, the Supreme Court has embraced the idea that the vesting clause grants powers beyond those specifically enumerated in Article 2. In Mayers v. United States 2026, the court cited the clause and the source removal as supervisory powers over executive officers. This was the Fitzgerald 1982 unambiguously cited the clause as the source of three powers: law enforcement, foreign affairs, and the supervisory power over the executive branch. In the 2003 case touching upon foreign affairs, American Insurance Association and versus Garamendi, the judiciary affirmed that the vesting clause grants foreign affairs authority. In a rather recent case, Free Enterprise Fund versus Public Corporation Accounting Oversight Board, 2010, the Supreme Court repeatedly declared that certain moral protections for commissioners were inconsistent with the grant of executive power, thereby grounding the president's removal power in the vesting clause. Though the court has read the clause and the grounding power, its decisions also have limited its reach. Post-Mayers, the Supreme Court essentially sanctions the creation of a fourth branch of government in the form of numerous independent agencies that simultaneously exercise legislative, executive, and judicial powers. The most notable such cases, Morrison v. Orson, 2018, 1988, acknowledged that the vesting clause granted the president control over prosecutions. The court concludes that the good cause removal restrictions imposed by statute, the executive could not remove, and his discretion did not unduly trample on executive authority. That framework encapsulates the Supreme Court case law on the vesting clause, while the clause grants the president substantive powers not found elsewhere in the Constitution. Congress may regulate, and to some uncertain extent, the exercise of those powers. The other perspective, the most compelling reading of the vesting clause by Christopher H. Schroeder. The opening sentence of Article 2 states that the executive power shall be vested in the President of the United States. The most natural reading of this vesting clause is that it establishes a unitary presidency with the power to execute the laws of the United States. Some would read it more narrowly, simply, as a signifier that the office of the presidency will be held by a single person. The less difference between those two options than meets the eye. The narrow reading does not alter the overall allocation of a prudential authority, because the prudential duty in Article 2, Section 3 to take care that the laws be faithfully executed should be taken to imply the power to accomplish what is necessary to discharge that duty. What I have called the most natural reading of the constitutional text comports with the widespread founding era understanding that the executive officer or officers of government have the responsibility for executing the laws. On the other hand, reading the clause more expansively to encompass unstated or residual powers, members of powers that are insulated from any ability of Congress to regulate via duly enact laws, would substantially alter the constitutional allocation powers. We're also being considered with the historical and the political context of the founding. Such a reading would give the president powers akin to the prerogatives of British kings, of which the founders were highly suspicious. To be sure, the experience of the United States under the Articles for Confederation and the individual states' constitutions between 1776 and 1787 led to significant dissatisfactions with government dominated by the legislature and to considerable interest in the federal government with a stronger executive. But the stronger did not translate monarchical. The antipathy towards monarchy and monarchical prerogatives remained, and in 1787 the political climate likewise remained inhospitable to the idea of executive holding substantial, unstated, unenumerated, or residual rights. This antipathy was most strongly expressed against the potentially oppressive authorities over which the president claimed unilateral sway, the common understanding of prerogative. Justice Jackson Swift from Youngstown Shades and Tube Corporation versus Sawyer, 1952, that the president's powers and the Lois ebb when they are asserted to be exclusive for legislative regulation comports more nearly with the founding era mode. The Constitution defenders asserted that it established a government for enumerated powers as well as when that is set ambition against ambition. What I have called the natural reading of the text is supported by the Ratification Convention debates. One of the recurring criticisms of the Constitution argued that it assigned power to the president that it would produce a return to monarchy. Opponents seeking to articulate these concerns pointed to a number of features of constitutional provision to support the claim of monarchical powers, but they never drew attention to the unstated or residual powers supposedly encompassed by the phrase executive power. Likewise, constitutional defenders did not feel compelled to demonstrate that any such residual powers were reasonable, even though they did respond to their critics by taking each of the stated powers of the president one by one to show each was reasonable and would not produce a bad result. Particularly prominent was the Hamilton discussion of prudential powers in the Federalist number 67 and number 69, in which he reviewed each of the president's enumerated powers, never mentioning the residual powers supposed contained within the term executive power. Thus, neither opponents nor proponents of the Constitution asserted that executive power had any larger meaning than that conveyed by the natural reading of the vesting clause. In 1793, after the Constitution was ratified, Hamilton, writing as Pacificus asserted that the Western Clause did have a broader meaning when defending President Washington's neutrality declaration. Whereas public officials, including opinion for the Supreme Court in Mayers versus United States, 1926, have subsequently also given voice to it. The Pacificus essay, however, leaned more heavily on other arguments based on specific and stated presidential powers, which were more than sufficient to carry the defense. As for Mayers, much of the opinion can be read consistently with the Western Clause in natural reading, because at least some ability to control and remove some executive branch officials is fairly implied and necessary to discharge the president take care responsibility as well as the president's law execution authority. Reasonable people can disagree as to whether the presidential power needs to be unfettered with respect to all executive branch officials. Mayer's apparent holding that it did not, that it did. Mayer's apparent holding that it did was the controversial dimension of the decision, and the Supreme Court rather quickly walked this part back. First in Humphrey's Executor versus United States, 1935, and later in Morrison vs. Olson, 1988, which held that an independent counsel could be protected from removal through a good cause requirement, because the hand protection did not impermissibly burden the president's ability to control or supervise independent counsel. Both President Richard Nixon and President George W. Bush in his first term provided glimpses into the implications of a very strong reading of the Western Clause. President Nixon and his representatives claimed an array of exclusive and preclusive powers. In President Nixon's case, this included the authority not to spend congressionally allocated funds, the right to decide what presidential communications would be made public, the right to prevent an executive official from disclosing information to Congress, and the right to render legal acts for subordinates that would be illegal absent presidential direction. President Bush's lawyers argued for similarly broad authority to ignore acts of Congress regulating presidential actions, relying after 9/11 on the president's duties as commander-in-chief, as well as on the allegedly expansive content of the Western Clause. These presidencies showed that giving the Western Clause a reading more broad than its natural meaning, and especially finding there was just Jackson in Youngstown termed conclusive and preclusive powers, would place an enormous repertoire of authority outside the system of checks and balances that animated our Constitution. And Jackson noted, because such claims put at stake the equilibrium established by our constitutional system, they must be scrutinized with caution. Neither Nixon nor Bush's aggressive assertions of such authorities were vindicated by the Supreme Court. By and large, the decision of the Supreme Court have adhered to the Jackson approach, declining to read more into the Western Clause than the text's natural reading. The constitutional overall structure and the clause's historical and the political context justify. The other perspective, The Significance of Executive Power by Krishna B. Prakash. I think we already read that. So, okay, that means we're going to conclude that. Let me see. Okay. I totally forgot. Yeah, I think I... Yeah. Won't read that. Okay.